Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
G'day, Nick.
Hello, Bowie.
How you going?
Great.
How's the little bloke?
Yeah, he's doing good.
Is he?
Yep.
Causing you any grief?
Sometimes I come home late.
Is he what you say? Does he listen to you?
Look, not really, but every night now I'm coming home and he's dressed as Spider-Man and we play the games and sometimes I get home late and I miss out.
Spidey time. Yeah.
That's causing problems.
All right. The hardworking Nick Maruchak, father of Lev, 133 882 if you'd like to speak to Nick. Mark, thanks for calling. How are you?
Yeah, good, thanks, gents. Righto, so the situation is, it's my friend, his mum passed away a few months ago. He's in his mid-50s. He's lived in the family home with his mum and dad forever. He used to work, his dad passed away a few years ago, his mum passed away, but before that his mum got sick with cancer. He became her carer. And now that his mum's passed away, he was recently told that the house has got to be sold according to the will. Now, he's not sure what to do, and he's looking for somewhere which way point him in the right direction, if that makes sense.
Yeah. Yeah, so this is what comes to mind, Mark. First of all, so I'm going to assume that your friend may be, since he's of financial need, right? And let's assume that your friend is in a worse financial position than the siblings. So if that's the case, one strategy is your friend can potentially challenge the will, right? So he's been allocated an equal share, the same as everyone else, and he can say, look, this is my circumstances. I'm in of further need of further provision from the will. And what the court can do is they could change the terms of the will and maybe give him more, right? So that's an option for him. He has to do that within 6 months of probate being granted. And that's a deadline. If he misses that, the time lapses and you have to get an extension. And if the other siblings are able to agree, there is a mechanism to change the will. You do it through something called a deed of family arrangement. It's a contract everyone over 18 signs to change the will. So your friend could probably start a discussion with the other family members to see how much of their share they're willing to give up.
Oh, okay, yep. All right, so I forgot to say, his sister, which he hasn't seen in years since his dad passed away, hasn't been in contact with him or his mum since, and never came to his mum's funeral either. So, and she won't speak to him.
Who's the executor?
I'm not too sure. I think it might be the public trustee, possibly. He's not too sure himself.
Yeah. So he would. So you want to get a copy of the will. You want to find out who the executor is. You want to find out what steps they've taken to apply for probate, because that 6-month deadline is ticking. So it sounds like he's probably not going to get consent from the sister. So he would probably, then the next step is to look at making this family provision claim. That's what it's called, challenging a will.
Family provision claim.
Right. Yep. There's lots of lawyers that do it. Elise Croft from Croftbridge is one lawyer that I know she does that kind of work, but many other lawyers would do it. Some lawyers would do it on a no-win, no-fee basis as well. But the first step is you want to sit down with a lawyer and go, do you think I can get more than just an equal share? He may not get the entire house, but he might get more than he's getting now, which might set him up.
Yeah, because, I mean, try and rent, try and buy for what you get. Poor guy, I don't want to see him homeless, that's all.
Yeah, so that's the steps you'll take, and that's the mechanism, and the court will decide what's fair, and they'll weigh everything up. But yeah, you can't challenge a will if you're well off. You can only challenge a will if you actually need further provision. You have to have that, and it sounds like he's got it. Yeah.
All right, mate. I hope that helps, mate.
Thank you very much. Appreciate it.
Cheers, mate. Thanks for calling in. 133 882 if you'd like to speak to Nick Maruchak. Our hardworking team have spotted this loophole in the town of Bassendeans in the area of Graffiti, Nick. If you live in Basso, someone graffitis your home, your residence, and if you refuse to clean it up yourself, well, the Bassendean Shire will come and do it for you.
Yeah.
That's nice of them.
That's right. So basically, I had a look at this legislation. There is legislation called the Graffiti Vandalism Act of 2016.
State Act.
Yep, state legislation. And it basically says that if you, if council gets your consent to remove graffiti, then there is a mechanism in the Act for them to recover their costs of removal. But if you don't give the council consent to remove it, then the local council has the power to go into your property and remove it, but then they can't recover the removal, that cost from you.
Woohoo.
So, and that's, look, Section 25, have a look at that. So this applies statewide then. So then if you have graffiti in your house and the council sends you a letter saying, can you please remove it, then there appears to be an incentive there to say, no thanks, I'll just wait for them to do it. Now, quit.
So in the first instance, they write a letter to me and say that you got graffiti on your fence, you need to remove it at your cost. And if you say no, then they will come and do it anyway. I wonder if the City of Stirling would do that.
And I think it will depend and if it is unsightly enough, right?
Yep.
So it's...
Public eyesore. Yeah, okay.
If it's a huge public eyesore, then they'll probably do it. But otherwise, you have to weigh the cost of having this graffiti in your house versus cleaning it up. And
Yeah. Many years ago, there was some anti-6PR graffiti on Orong Road, targeting the station manager and myself.
Wow.
Suggesting a certain act that I would enjoy. And the local council, which I think out there is, what was that, Vic Park, I think they removed it for us. But yeah, it was, they say all publicity is good publicity, Nick. I don't know if that's true. 133 882. Family law is very much in your remit. Big changes to the Family Law Act around pets.
That's right. So the changes came in this week. They apply to people who are married, so they don't yet apply to de facto couples, because de facto couples are dealt with by state legislation. This is a nationwide one. And it basically allows the court to make orders for pets. In the past, pets were treated like property in the same way a car would. But now the court can say, look, they acknowledge that pets people have an emotional connection to their pets. So they would take a bunch of factors into account, such as who's cared for the pet, who's contributed to it, if there's any attachment to the pet for any children and stuff like that. And then they can make an order on who keeps the pet, right? So they can say you have the pet or you have the pet based on these factors. If the court also have the power to sell the pet, but one thing they can't do is they can't have like a custody style order for the pet, right? So you can't say you have the dog on this weekend and then next weekend it's shared. And my guess for that is probably because if people have an disagreement about this, it's probably going to clog up the courts with fights about that. So, and they're already under strain. But
all right. It won't be a function, a drop-down menu on MyGov anytime soon. Big changes to the Family Law Act. Give us a call. Lots of times to get your calls in if you'd like to speak to Nick today. 133 882. Anything you'd like. Of course, Nick specialises in family law. We'd love to hear from you today. 133 882. Is Nicole there, Jimmy? She is?
Ready to go.
Yeah. Hi, Nicole. How are you?
Oh, good, thanks, Simon. I was just hoping for some advice. My mum was involved in a very bad car accident 18 months ago. She's just received a large sum payout from inquired. She does get a part pension and has superannuation. So I presume we have to go to Centrelink. And does she have to now she's over 80, start lodging tax returns?
So that is an accounting question, and
I thought so, yeah.
I can have a quick look at this, but you would have to speak to your accountant about that, because let me get back to you on that one, Nicole, because that one just stumped me on the face of it, because there is an argument there to say, well, that's not taxable income, right? So that is a payment for pain and suffering. So so you have to have a look at, actually, I think it's coming to me now. So when you get these personal injury payouts, a portion of it is going to be allocated to lost income, right? So if that's allocated to lost income, then there's a good argument that that is taxable, right? And the government's entitled to that. But then the portion that's allocated to pain and suffering or injury to your body and stuff like that, that stuff, my understanding, but check with the accountant, is generally not taxed, right? So that's tax-free. So it depends on how the insurer has allocated, and normally in a lot of these claims, they separate them into various categories. So have a look at that. And if the entire thing is for pain and suffering, then there won't be tax. And also, if your mother's under there's a tax-free threshold, right? And if your mother's under that, then, well, you might have to declare the portion that's been allocated to lost income, but you just don't pay any tax.
If she's 80,
she's over 80.
Yeah, there's no lost income, is there, if she's over 80?
No.
Yeah,
She's
she's
on
not,
like
not
a
working.
super.
There wouldn't be though. So, but you do have to check because it's these are technical things. So, if there's no portion allocated to tax income, then potentially lost income, or anything of that nature
Will be minimal. Yeah. All right.
Probably not.
Might be worth getting an accountant to have a look at it, Nicole. But off the top of Nick's head, and I could hear that. I could hear him. There was actually noise while he was thinking. There was a little whirring sound in the background. Nick reckons she won't have to declare that in her tax return because it's a payment for suffering. Thanks, Nicole.
Thank you.
Cheers. We'll stay there, mate. We'll come get you in just a second. It's 15 minutes to 11, or as normal people say, quarter to 11. 133 882 if you'd like to give Nick Maruchak a call from MKI Legal. Hello, Will.
G'day, Simon. G'day, Nick.
Hi, mate.
Just wondering if a person can be the executor, the sole beneficiary, and along with their spouse, be the sole witnesses to the signing of a will.
So, yes, a person could be a sole beneficiary and an executor, but it's recommended that they don't witness the will, right? So a will needs to be witnessed by two people. It's good practice not to have the beneficiary and their partner witness the will because that can lead to allegations of undue influence and stuff like that. But if that's already been happened, then there is, under the Wills Act, there's technically nothing from preventing it, right? So the will should still be valid, but it just opens them up to a lot of allegations later.
Right.
Yep.
Would they need to apply for probate?
You only need to apply for probate if you need a court order, right? So say if you have a joint property with your husband and wife, the property automatically goes to the other person. You don't need to apply for probate. But if the house is in sole names, you would need to. So it just depends on what assets they have, on whether they need to apply for probate.
Right. So if the husband died first, it was my mother, and the house went to my mother, and then she passed away.
Then definitely.
And they've got to apply for probate.
Yeah. But usually when a husband and wife own property together, the house automatically transfers, so you don't need probate in that case, unless there's an asset in a bank account that's more than 50 grand or something. Yep.
But if the wife dies, then whoever's the beneficiary needs to apply for probate?
Yep.
Okay. Very good. Thank you, Nick.
Thanks, Will. Good on you. Thanks for calling in. G'day, Jodie.
Hi, how you going?
Going well, thank you.
Just have a question. My son recently separated from his partner. They have a child together. He wants to stop her being able to move, whether it be up north, down south, interstate, with that child. Is there a form that he can complete for that?
Yeah, so you would apply to the court to get something called as an injunction. So if someone is threatening to leave the state or threatening to leave the country, then what normally happens is you make an emergency application to the court and you ask the court to stop them from leaving. The court will make this decision based on the best interest of the child, so they'll take into account all the factors, but these things can be complicated, and you really want to make this application if you have some sort of evidence that they are going to move. So if the partner's made a threat of moving, then he probably needs to act quickly and lodge this application with the family court. So if you like, Jodie, I can give you a quick call after and give you some recommendations on either some lawyers or some steps you can take. But that's the process you'll need to.
That would be fantastic.
Yeah.
Thanks, Nick. Thanks, Jodie. Thanks for your call. Good luck with it all. Fiona has SMS'd you, Nick. Hello, Fiona. She says, how long does an ex-partner have to rearrange her mortgage in her name for the home if she has agreed to the settlement?
So you normally...
Thanks, Fee.
Yep. So normally when you have a settlement, you have something called consent orders documented, approved by the court, or binding financial agreement. It's whatever is in the terms. So usually the consent orders will specify you'll have 60 days or 30 days, right? If there's nothing in the consent orders and there's no time limit in the agreement, then it's a reasonable period of time, right? So a reasonable period of time varies from case to case, but I would say 60 days is probably pushing it. And if you can't get the finance and you can't refinance, you've tried everything, then it's time to consider potentially either the other person taking over the mortgage or selling. So
hope that helps, Fiona. Thank you very much for your correspondence. G'day, David.
Good morning to you both. Nick, I have a will in place. I have 3 daughters, and they are the beneficiaries of my estate. And I've nominated them as joint and several executors.
Mm-hmm.
How do I go about finding a lawyer or somebody to give them assistance in carrying out their duty as executors, or taking it over if they don't want to have anything to do with that duty?
So the way I would approach it is you want to give your children the first choice to act as executors, because an executor can hire a lawyer to help them, right? So generally speaking, I would say keep your children as executors, and they have the option to engage a lawyer. If you do have a law firm in mind that you think will be a good fit, then what you can do is let them know about it in advance, or write a wishes list. So you write something, these are my wishes, right? Make sure you write it, keep it away from the will. Make sure you say, this is not a will, this is not a legal binding document, these are just my wishes. And that's where you can give them some advice and give some messages to your executor that your executor can take into account when they act. So that's the way I would do it. I would leave them on, and if one of them drops out, it's fine. The other 2 can keep staying. But you always want to give them that first right to decide on who helps them.
I want to be a bit more proactive and
get them to get some help, professional help for them, Dave. You're asking? Yep.
Yeah.
Yes.
So I would say a lawyer would be the best person to help. There are also, there are also professional executor companies, right? But they can charge a lot. So I would say maybe have a chat with a lawyer, have a meeting with them, and then let your daughters know this is someone who can definitely step in, and give them their contact details and have it all ready to go.
Does that help, Dave?
That's a great help, yes. Thank you very much.
Cheers, mate. Thank you for phoning in, and good luck. Hope you live forever, mate. Hello, Diana.
Good morning. Thanks for being there. I downloaded from the government website the power of guardianship papers, which my son signed. When the hospital refused to treat him, I used that power of guardianship to ask why they didn't. And they have insisted that they need permission from him to speak to me. And he is mentally ill and not in a position to give any sort of legal agreement. So the hospital, as I said, has refused to give me the information I require. How do I go about getting it?
Yeah, this is...
Should they respond to me under the power of guardianship, or can they ignore me?
So, I mean, if the first thing is, when it comes to these kind of medical treatment, the first thing the doctors in the hospital do is can the patient give consent, right? They go to the patient first, and they have to decide if the patient's got consent or not. If he can't give consent and he's that mentally ill, then the person who's guardian under the power of guardianship is able to give that decision. And sometimes if they can't find that person, then there's a whole list under the Guardianship and Administration Act that goes through and specifies the order, right? So the hospital has probably made a decision that your son can give consent, but you probably think he can't, right? Is that right, Diane?
He has been a mentally ill patient at that hospital on a revolving door basis for the last 2 years.
Yeah. So if he can't give consent, you will be entitled to it. But if he can give consent, then the hospital's right. So if you like, I can give you a quick call, find out a bit more details, and try and point you, give you some strategies after.
Thanks, Nick. Thanks, Diana. Thanks for phoning in. Nick, thank you for today, mate. Well done. I hope you get to get some Spidey time with Lev a little bit later on this evening. Hope you get home in time and do some good parenting.
Yep, that's right.
All right. See you next week, mate.
Thank you, mate.
Thank you. Nick Maruchak from MKI Legal. Do our pollies deserve a pay rise? The no's are 86. and the yeses are 24. When we come back, Nick Collis will join us after the news.